that are used in the various sections, these terms are basically defined, and these term has that meaning. In every statute, you will find, you pick any statute, whether it is Indian Penal Code, Indian Contract Act, or it is Partnership Act, or any other legislation, you will find that there is a one section in which there are definitions, the different terms, the different words that use in particular statute is explained in that particular section, and that section is known as definition section or definition clause. Generally, it is section 2 or section 3, like in Indian Evidence Act, it is section 3. Now, what is the purpose? The purpose is quite clear, that if you will not define a word that used in the provision, in the substantive provision, then it will create confusion in mind of the law enforcing agency, and even in the confusion during the time of the issue before the court of law. So the one lawyer will stretch it in one direction, the other lawyer will want to give its narrow interpretation, and so it's important to define that word. Okay, see, in every statute you will find a particular section, a particular provision that dedicated to definitions. Even our constitution also, but because it is our the foremost document, so we have provided definition not in section 2 article 2 or 3, but घर होता है ना, नया घर बनाते हैं तो सारी चीजें पीछे रखते हैं. So in section article 366 of the constitution you will find definitions, and there the various words used in the constitution have been defined. Then section article 367 interpretation also provided. Similar scheme you will find in the Indian Penal Code. The whole chapter 2nd from section 6 to onward 52 is basically dedicated to the various words used in the Indian Penal Code, like death, man, woman, number, everything. And then section 7, that is very important. Section 7 of the Indian Penal Code says that if a word used in the Indian Penal Code and is defined, it will take the same meaning. Okay, so that is the beauty of the Indian Penal Code. Similarly, in the Competition Act also, section 2 define various terms, various words that are used in the section 3, section 4, section 5, or you can say subsiding sections, subsiding provisions of the Competition Act. Now, see, there is one approach, either to discuss that word when we discussing this section, or to discuss these words separately and then start the provision itself. And so we thought that there should be a particular chapter in which these words has to be defined, and a question is also asked on what is relevant turnover, what is relevant market. Sometimes question also asked on this particular aspect without specifying that how this particular thing will affect the competition. And that's why we provided this chapter. In chapter 2, basically we discuss 8 definition, 5 plus 3, 8 definition. First is agreement, because when we will discuss section 3, the section 3 is basically anti-competitive agreement. Now there is one confusion, that word agreement is used, and as a law student you know that the agreement has been defined under the Indian Contract Act. Section 2H define contract under the Indian Contract Act 1872. That contract mean an agreement enforceable by law. Okay, and then the word agreement is also defined. Then the word proposal, acceptance, section 2A proposal, section 2B acceptance, section 2C promisor, promisee, section 2D consideration, section 2E then consideration, and the promises that forming reciprocal promises become the agreement. Now here the word agreement has to be understood in different context, because when two business tycoons, suppose there are two business tycoons, suppose there are two milk producing enterprises in Delhi. One is suppose Amul. I'm just giving the hypothetical examples so that you can understand. One is Amul, another is Mother Dairy. अब इन दोनों के सीईओ जो है किसी एक बिजनेस मीटिंग में मिलते हैं और वहीं वो चीयर्स करते हुए कहते हैं यार मार्जिन बड़ा कम है प्राइस में, मिल्क प्रोड्यूसिंग इसमें बिजनेस में, तो ऐसा करते हैं ना हम लोग प्राइस इंक्रीज कर देते हैं. So there is meeting of mind between these two enterprises, and this meeting of mind has not been written. This meeting of mind is also lacking the elements that is required under the Indian Contract Act. So if this word has not been defined under the Competition Act, it might cause the confusion, and that's why legislature has defined all these words. So the first word will be agreement. Section, you can write it, section 2 clause B, agreement, that we will discuss. Then the second word will be cartel, 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 section 2C. So basically cartel is a organization, a group, various similar enterprises like cement producing companies है तो वो सीमेंट अपने इंटरेस्ट को प्रोटेक्ट करने के लिए सीमेंट प्रोड्यूसिंग कंट्रीज का एक ग्रुप बना लेंगी. जो आपका कपड़ा प्रोड्यूसिंग इंटरप्राइजेज है वो अपना ग्रुप बना लेंगी और उनका फिर मेंबरशिप भी होता है. सो दैट कैन यू डू बिकॉज द एसोसिएशन इज द फ्रीडम ऑफ एसोसिएशन इज वेल protected right under the Indian Constitution. But when this particular group used for defeating the competition by meeting the mind, by entering into an agreement, formal, informal, any type, then it became a cartel. And cartel activity is, very difficult to approach, curb, because the outsider, other enterprises who is not the member of cartel, is basically will face a very the monopolistic behavior, and so the cartel is very dangerous to the competition in the market. Then the next definition we will discuss is consumer. Earlier when I was student of LLM, Competition Law and Consumer Protection 1985, both used to taught in one particular subject. So because it ultimately the Competition Act will be beneficial to the consumers, because if there is a healthy market between the various enterprises working in the market, then there will be benefit to the consumer, because they will receive the goods or services at cheaper rate, and the quality of goods and services will also be high. Suppose there are various automobile industry, in automobile industry there are various enterprises like Suzuki, Maruti, then Honda, then Hero, etc. And there is a competition between these enterprises. So every time to increase their sale, they are investing the money in research and development. Otherwise, other company will take over the market. Like abhi Kia ko jo aa raha hai, South Korean company hai. So every buyer want to purchase this Kia car. Yeah, okay, that's why every company, every enterprise is eager to launch the new product, and that also at some quality, the cheaper rates. So that's why the word consumer, section 2F. And then you can also compare that how the word consumer defined in the Competition Act is different from the consumer defined under the special legislation, the Consumer Protection Act 1985. Then there is word enterprise, and that is very important, because the competition, when you read section 3, basically it related to the agreement that is anti-competitive effect in the market between two enterprises. It does not mean any between two person and other type of the competition. So word enterprise also important, section 2 clause H. And enterprise, when we will discuss that an entity that must have some business connection, etc. Okay, in more detail we will discuss when we will discuss this particular chapter. Then word goods, section 2I. Then word practice, section 2M. Then relevant market, and that's very important, relevant market, section 2R. And relevant market, I think also include relevant product market and relevant geographical market. Okay, then relevant turnover, and that is very important, because relevant turnover is important to for Competition Commission of India also to determine penalty that has to be imposed when the conduct of enterprises are anti-competitive. That means either it is in violation of Section 3 or Section 4 or Section 5. Now, there is one case in your case material that we will discuss, and that is, by the Supreme Court that define that what is relevant turnover, and the name of the case is very important. Every time examiner want to ask question on this particular, definition, relevant turnover. The name of the case is Actual Crop Care Limited versus CCI, Competition Commission of India, 2017, 8SCC 47. So basically in this case, Supreme Court has defined that what is relevant turnover. Now some little other definition like services are also we will discuss. But so these basically 8 things we will discuss during the chapter 2nd. There is another case that we have provided and that we will discuss under the chapter 2nd. That is CCI versus Coordination Committee of Artists and Technicians of West Bengal, Film and Television, Supreme Court appeal. Okay. So these 2 cases we will discuss under this chapter, and overall weightage of this topic is that of 20 marks. I'm not telling according to this OB online book exam, open book exam, but according to the offline exam. Okay. So 20 marks. 20 marks means one full-fledged question can be asked from this particular point. That can be divided in 2 parts, like one definition is what is enterprise, and then another may be relevant turnover or maybe relevant market. So that's the, you can say that choice of examiner. Examiner can ask in any way, but the overall weightage is 20 marks. So it's very important unit. Okay. If you have any question from this chapter 2, you can ask me anything, any clarification. Otherwise, I will move further.
Good afternoon, sir.
Mm-hmm.
Sir, my question is, under Indian Contract Act, the definition of agreement, it talks about consideration, and
Ji,
in this act, the definition of agreement, it includes understanding or arrangement. Sir,
ji,
what
ji.
is the difference between the two?
See, if you see the basic, that why two enterprises enters in an agreement that is anti-competitive, because it is for benefit of both the enterprises. They don't want to, they don't want to, allow the other competitor to come into the market. They want to earn more profit. And that's why this consideration thing is not important for them. If there is an agreement, and because what is the fear? Suppose me and you both are the enterprises. मेरे को ये fear होगा कि अगर मैं price बढ़ा देता हूँ, आप ज़्यादा sale कर जाएंगे, आपकी enterprise ज़्यादा चीजें बेच जाएगी. लेकिन हम दोनों एक understanding में होंगे कि नहीं, हमें दूध है वो 25 रुपए पर किलो या 50 रुपए पर केजी ही बेचना है. तो अब now I don't have any fear that you will take over even my market share. And so there is no concept of consideration, and that's why this term is very important to define here, because the Contract Act and the Competition Act both are, in the different field. Okay, so here the understanding, here the mutual, the agreement, here the meeting of mind is with respect to defeating the competition, not with respect to supplying of some goods or the services. In case of supplying some goods or services, there needs some consideration. But here is not for supplying of some goods or services. So you don't want anything like goods or services in favor of you, but you only want that you also do the same thing where we have reached at the consensus. Okay?
Thank you, sir.
Yes. Now see, after this chapter, there are 3 chapters. Chapter 3, chapter 4, and chapter 5. And these chapter are, you can say, the soul, the gist of the competition law. And because in the Competition Act 2002, when the Raghavan Committee gave the report, Raghavan Committee, who recommended for the Competition Act, said that there may be 3 behavior of the enterprises that can defeat the competition. सिंपली कंपटीशन को तीन तरह से डिफीट कर सकती हैं enterprises. So there are three behavior or three ways to defeat the competition. First is that enterprises may enter into an anti-competitive agreement. एक ऐसा एग्रीमेंट वो अपने बीच में कर लें that causes appreciable, not small, but appreciable adverse effect of competition in India. If that is thing, then that may affect the competition. Second is that there may be one enterprise, but that enterprise is such a dominant position, and after coming into the dominant position, it abuse its dominant position, and so that can be also responsible for defeating the competition. The third thing is that combination. Suppose in a particular market there are three enterprises. Suppose in the aviation sector there are three airlines: airlines A, airlines B, and airlines C, and now there is merger of these airlines. After that, when there were three airlines, there was competition. वो 800 की टिकट देता था तो वो 700 की टिकट देता था. But after merging, there will be one airlines. वो चाहे 1000 की बेचे या 2000 की बेचे. Whoever want to go, whoever want to use aviation, whoever want to use the air service for going somewhere else to some other place has to buy the ticket. And that's why this combination may be merger, it may be acquisition, it may be amalgamation, takeover. It also causes some effect on the competition. So these three things basically recommended by the Raghavan committee. One is anti-competitive agreement, abuse of dominant position, and combination. And accordingly, the parliament has enacted three sections. Section 3 basically talk about anti-competitive agreements. Okay, so section 3 anti-competitive agreement, section 4 abuse of dominant position, and section 5 and 6 both related to regulation of combination. Okay, now our chapter 3 is dedicated to anti-competitive agreement, and this is the chapter where we will discuss only one section, that is section 3. तो सिंपल तो है कंपटीशन एक्ट कि एक ही सेक्शन एक ही पूरा चैप्टर उस पे है. ओके, अंडर दिस एंटी कॉम्पिटिटिव एग्रीमेंट चैप्टर 3 we will basically discuss 8 subtopics, you can say. First is anti-competitive agreements and prohibition. So section 3 subsection 1, section 3 subsection 2, these two things we will discuss, that what section 3 subsection 1 says and what is its legal implication, legal effect, what is section 3 subsection 2, and what is its legal implication or legal effect. Okay, then we we will discuss two things. One is that this agreement between two enterprises that can be anti-competitive. It may be that the enterprise is at same level of the production chain, or it may be between two enterprises who are at different level of the production chain. Now the question is that what is production chain? Suppose if you talk about like our like this biscuit. So जो हम घर पे बिस्किट का एक पैकेट लाते हैं तो कैसे होता है? पहले फर्स्ट ऑफ ऑल देयर इज मैन्युफैक्चरर. So manufacturer ने उसको प्रोड्यूस किया होगा. Then manufacturer has supplied through its supplier. Then the third step is supplier supplied to wholesaler, and then wholesaler से retailer के पास आया होगा, and then retailer to the consumer. So basically there are 4 steps: manufacturer, supplier, wholesaler, retailer, and then lastly consumer. So these these enterprises, who is retailer or who is wholesaler or who is supplier or who is manufacturer, are basically the enterprises at the various level of the production chain. Now see that like the Reliance also come in the retail. Okay, so this retail sector is different, wholesaler is different, supplier is different, and then this manufacturing sector is different. So there may be a company, or there may be the group of company. In that group of company, some company are at the manufacturer level, some are at the wholesaler layer, some are at the retailer level also. Now, if there are two enterprises like two wholesaler and two wholesaler in a particular, like in the Delhi, there are two wholesaler for this water bottles. Okay, and these wholesaler entered into an agreement, an understanding of type of thing that they will supply their product at this much of the price. Now the question is what type of the agreement is, whether it is horizontal or vertical. Yes, please answer. Yes, can anybody answer that there is an agreement between two wholesalers working in Delhi who supplies water bottles, the packed water bottle. Is it horizontal agreement or is it vertical agreement?
Sir, horizontal agreement because it is
Yes.
at the same level.
Yes, but if there is an agreement between manufacturer and wholesaler, hmm? Manufacturer A जो water bottle किनले की बनाता है, then there is the wholesaler like B who supplies water in whole Delhi, and then you know any person who want to do the business of wholesaling उसको किनले का वाटर सप्लाई नहीं करेगा, तो जो भी रिटेलर उसके पास आता है कहता है कि जी आपने हमें जो है बिस्लरी दे दिया और पानी दे दिया, लेकिन आप किनले क्यों नहीं सप्लाई करते हो, अगर किनले सप्लाई नहीं करोगे तो हम आपसे लेंगे ही नहीं. So ultimately the business will be affected of this the separate enterprise who came in the market. And so sometime the agreement between two enterprises who are at the various level of the production chain can also cause uh, that can also affect the competition in the market. Okay, so first thing, the anti-competitive agreements and prohibition, section 3 subsection 1 and subsection 2. Then we will discuss horizontal agreement, then we will discuss vertical agreements, that what are the vertical agreements and how vertical agreement has to be examined. Horizontal agreement are per se means that if there is the horizontal agreement, then there is nothing more to explain, nothing more to prove in the in before the CCI that it is anti-competitive. So the fourth thing we will discuss, rule of per se, and then the fifth thing is rule of region. In the vertical agreements we have to apply the rule of region, because sometimes the vertical agreement like there are various type like the tie-in agreement, exclusive supply agreement, exclusive distribution agreement, refusal to deal, resale price maintenance. These 5-6 type of the agreement between two enterprises at the various level level of the production change. Like there is the exclusive showroom of the Vimal, that is the brand of the Reliance, so or the Nike or Adidas. So you will find that product in that particular showroom only. So it may be like if you are also opening a particular shop and you went to the this Adidas company, that you also want Adidas product, because your consumer has variety of choices, and if you will not supply these Adidas shoes, it will hamper my sale. But he is not supplying because he have the tie-in this exclusive supply agreement between this brand showroom and between the manufacturer. Now see, this type of thing does not mean it always cause the appreciable adverse effect. And so the next thing we will discuss is that appreciable adverse effect on competition in India. This AAEC, appreciable adverse effect on competition in India, and how we will determine that whether a particular agreement will cause appreciable adverse effect on the competition in India or not. Because section 3 clause 1 require that if an agreement causes appreciable adverse effect, then it is anti-competitive. If there is an agreement and it does not cause any appreciable adverse effect, it does not adversely affecting. अगर positively affect कर रहा है, then it's very good because competition तो चाहिए ही. But if it appreciably adversing effect कर रहा है, then it is anti-competitive. So how to determine this appreciable adverse effect? We will take the help of section 19 clause 3. There some yardsticks, some guidelines are provided by the legislature, that on those guidelines, accordingly from the cases to cases, you have to determine that whether this particular agreement causes appreciable adverse effect or not. Okay. Then the next thing we will discuss, the seventh thing is cartel. So what is cartel, as I told you, and how to determine cartelization? On this particular point, we will discuss very important and interesting case, that is this Builders Association of India versus Cement Manufacturers. Builders Association of India versus Cement Manufacturer. This case is basically on cartelization. Then there is an other case also, Shamsher Kataria versus Honda CL Car India Limited. Shamsher Kataria versus Honda CL Cars India Limited, 2014 Competition Law Review. Okay, so these cases we will discuss. There are some other cases also that we will discuss during our discussion. Then there is another concept, and that is bid rigging. So what is bid rigging? See, there in various sectors, the tender is submitted and then there is bid, okay, and accordingly the product is sold out, or that particular tender is allotted. But in bid rigging, if the parties, competitive parties, have the collusion, they have the agreement, they collided, okay, before the bid, then that is not a proper bid. That is bid rigging, like election rigging. Okay. So on the bid rigging, we will discuss that what is bid rigging and how it happened. And then there is a very important and interesting case, Rajasthan Cylinders and Containers Limited versus Union of India and another, civil appeal number 3546 of 2014. So this case is on the bid rigging, and believe me, there is always either a question on the cartel or in the bid rigging, or this, how this rule of region has to be, applied, and what are the yardstick guidelines with respect to some cases you have to answer a question. So this is that chapter 3, and chapter 3 weightage is 30 marks. That means you can expect one full-fledged question and one half question. So that is the weightage of this particular chapter. And this is very interesting area. You will really enjoy, because you have to read the section in the Competition Act, then we will explain, and according to cases, we will decide the matters. Okay. Can we move further?
Sir, topic 3 is 30 marks or topic 3 to 5?
No, 3 is 30 marks. That means one full question, one half question. 30.
Okay, sir.
Okay. Now come to the chapter 4. Chapter 4, basically under chapter 4, we will discuss basically section 4, and slightly like section 19 clause 4 also we will discuss, that talk about that how to determine, this dominant position, etc. Okay. And some provision from this definition section, like relevant market, etc., that we already, I think we will discuss under chapter 2. So chapter 4 is regulation of abuse of dominant position. Basically, we will discuss two things. First is what is dominant position, and second thing is what is abuse of dominant position. Without abuse, when an enterprise is in the dominant position, it is not bad. It is not prohibited under the Competition Act. Like suppose in the banking sector, SBI is in the dominant position, so it is not bad. Suppose in the insurance sector, LIC is in the dominant position, it is not bad, unless the enterprise that in the dominant position abuses its dominant position, it is not prohibited under the Competition Act. So to attract Section 4, twofold inquiry is there. First is to prove that the enterprise is in the dominant position, and second, you have to prove that the enterprise has abused its dominant position according to the Section 4 Clause 2. In the Section 4 Clause 2, basically there are the ways that how an enterprise that is in the dominant position can abuse its dominant position. Okay, and this case of DLF, Bel Air Apartments, Bel Air Apartment Owners Association versus DLF Limited and HUDA, HUDA, Haryana Urban Development Authority. This case is glaring example that how the DLF, that is in the real estate market, in real estate sector, has abused its dominant position, because unilaterally DLF has changed the various clauses, has increased the height of the floors. पहले जब उन्होंने जब घर अलॉट किए उस समय बोले कि नहीं टावर जो है 15-15 मंजिल के बनेंगे. आई एम गिविंग द जस्ट एग्जांपल, नॉट फैक्ट आर नॉट एज अकॉर्डिंग टू द केस. एंड उसके बाद में जब वो सारे अलॉट हो गए तो उन्होंने 30 मंजिल्स के टावर बना दिए. सो यूनिलैटरली दे हैव चेंज्ड एंड सो मेनी थिंग्स they did. And the customer does not have freedom, because customer always want to connect with the DLF. So यहाँ पे होता बेसिकली क्या है कि जो इंटरप्राइज डोमिनेंट पोजीशन में होती है, कस्टमर के पास चॉइस नहीं होती, बिकॉज उसका रीसेल वैल्यू, उस प्रोडक्ट की लोकेलिटी एंड ऑल दीज थिंग्स, कस्टमर आर बेसिकली एडिक्टेड विद इट. एंड सो this type of enterprise, when abuses its position, it is prohibited under Section 4. Then the third thing that we will discuss, the first is dominance of in the relevant market, second is abuse of dominant position, and third is predatory pricing. So predatory pricing, sometime the enterprise supplying the goods or the services even at the less than the production cost. अब आप कहोगे सर जब प्रोडक्शन कॉस्ट से नीचे सप्लाई कर रहा है तो फायदा क्या है, दिक्कत क्या है? Suppose there is a automobile sector, and in manufacturing of one car of a particular what you say, that particular brand, the production cost, in production cost include all type of the cost. That cost concept also we will discuss, supply cost, distribution costs. Suppose it is 10 lakh, but still that car company is selling the product at 8 lakh rupees. So this is predatory, and the basic purpose is that then they will catch all the market, and the other enterprises, other business holder, other stakeholder, they will not have any business, and ultimately the other enterprises will collapse, and then there will be one monopoly in the market. So that happened many times in the American market. It was argued by the American companies that the Japanese companies are using predatory pricing in the American market. They are supplying the TV set in the America at very low cost, and the same TV set in the Japan is at very high cost. And because the same enterprise is supplying in the two various nations, and so they can manage, they can compensate their the cost. But basically with this predatory pricing in the American market, the American company will collapse. So this competition overall they can defeat, and at the time when there is no American companies in the American market, then they will increase the price. So that this predatory pricing. So these three things we will discuss. Now the question is how to determine the dominant position. So the dominant position does not mean the dominant position of a particular enterprise in every sector. That must be relevant market, like whether SBI is in dominant position or not. So ऐसा नहीं कि SBI के हर जगह dominant होगा. First we have to determine the relevant market. So the relevant market is the banking sector, and in that also the banking sector, in that also you have to determine that relevant market has to be determined with relevant geographical market and relevant product market. So both these components, relevant product market and relevant geographical market, basically will determine the relevant market. And in that relevant market, with the turnover, with the consumer data, there is not only one condition, but there are various factors that shows that can establish your dominance in the market. Okay, and then according to section 4 clause 2, we have to prove that whether it has causes the abuse or have not causes the abuse. Under this chapter, the first case, as I told you, the Bel Air, that was a society developed by DLF. So Bel Air Apartment Owners Association versus DLF, Delhi Landfilling Limited versus and HUDA, HUDA, Haryana Urban Development. The second case we will discuss MCX Stock Exchange. So if any of you have the knowledge of the share market, knows that what is MCX Stock Exchange and what is this NSE. MCX Stock Exchange versus National Stock Exchange. Okay. Then the third thing is through in the this online cab sector. So there are two companies, this Ola and Uber. Fast Track Call Cab Private Limited and Meru Travel Solution Limited versus ANI Technologies Private Limited. Okay, so that case you can find in your case material is there with. And then fourth case is Indian Exhibition Industry Association versus Ministry of Commerce and Industry and Indian Trade Promotion Organization. Because a government sector, a government department, a government association that also having the business can also be enterprise. So it does not mean when you are the part of the government, you are the government organ, you can do the anti-competitive activities. In the detail, when we will discuss, you will learn so many new things about the competition law in India. Okay, so these and then there is this Matrimony Company Limited versus Google, LIC and others, CCI 2012. So all these cases we will discuss under this chapter. Then the next chapter is chapter 5, and that related to combination. The name of the chapter is Regulation of Combination. This fourth chapter also has the weightage of 30 marks. Okay. From the fourth chapter, if you have any question, you can ask me. Yes. Any query, any question, any suggestion, any other comment that you want to make? From
Sir, when we will read the topic, then we will ask questions, sir.
यस नहीं अदरवाइज समटाइम द स्टूडेंट वो पूछ लेते हैं कि सर इसमें केस क्या होगा या इसमें कई बार क्योंकि जब टीचर काफी फास्ट बोलता है तो कई बार ना कुछ चीजें रह जाती हैं तो बिकॉज व्हेन आई वाज स्टूडेंट सो हम आपस में पूछते थे अरे सर ने क्या बोला होता है ना सो 30 मार्क्स बोले या 20 मार्क्स बोले so that type of the confusion I am giving one chance if someone want to ask. Yes, so next is our chapter 5, and chapter 5 basically related to combination. The name of the chapter is Regulation of Combination, and here we will discuss section 5 and section 6 along with some you can say these bylaws. Okay, that these bylaws also we will discuss. Now combination may be of 4 types. It may be merger, it may be acquisition, it may be amalgamation and takeover. So what is merger, what is acquisition, etc., that we will discuss. The second thing is that section 5 and section 6 is not related to every type of enterprises. ये नहीं कि यहाँ पे अपने लॉ फैकल्टी के बाद एक विष्णु की चाय की दुकान है और एक दूसरे की चाय की दुकान है और वो दोनों चाय की दुकान मर्ज हो जाएंगी, एक ही जगह एक ही ओनर अगर उनको खरीद लेगा तो बहुत भारी जो है कंपटीशन पे नुकसान हो जाएगा. So basically there is threshold limit that the enterprise that have this much of turnover, this much of capital, that enterprise, the combination of those enterprise is only subject to the inquiry of section 5 and section 6. Basically section 5 and section 6 not applicable to every combination, but some combination that above the threshold limit that provided under section 5 of the Competition Act. Okay, here 3 things we will discuss. First is the various kinds of the combination, as I told you, merger, acquisition, amalgamation, takeover, and that may be the horizontal and that may be the vertical. Horizontal and vertical, as I told you, that horizontal enterprises are those enterprises which are at the same level of the production chain. So maybe there are two manufacturer, there may be two supplier, there may be two service provider, there may be two wholesaler, there may be two retailer. And if there is a combination between these two, like this Flipkart and this other company, I yes, yes, Flipkart and Walmart combination. So on that also we have one case in our case material. Both these companies are in retail sector. Okay. Okay. Then the second thing we will discuss is regulation. So regulation section 6. So how that regulation procedure, it does not mean that combination है तो वो prohibited है. No, that combination may be regulated, and then the inquiry is made by the CCI. And if CCI approve it, it's well and good. If CCI does not approve it, then you have not to carry on. And then if you further carry on, then there is penalty. So first is combination, then second is regulation, and third is penalties. So these three things, these three topics, these three issues we will deal under the chapter 5. And with this, to understand this whole procedure, first we will discuss various provisions, how to make inquiry. उसके बाद में 26 में prima facie या उस 28 में कैसे जाएंगे, 30 में कैसे जाएंगे, कौन से penalty के provision है, कौन से bylaws में किस तरह से आप complaint डालोगे. So all these things we will discuss. That is the practical aspect. And then we will discuss the adjudicatory aspect, that how basically you have to analyze, you have to evaluate that in light of all these facts, whether this particular combination is allowed or not allowed. So for that, we will discuss three cases. One is this Etihad Airways and Jet Airways combination order. Second, as I told you, Walmart and Flipkart combination order 2016. And the next is this Sun Pharma and Ranbaxy combination order. Okay. One another case is there that just a link has been provided, but you can read it. PVR and DT Cinema combination order. So these three cases that we have provided in case material, and one case that we have provided the link, you can read it. And other combination also you are at liberty. In the books you will find some examples of other combination. But the approach of law faculty of Delhi University is to discuss 2-3 cases so that student has an idea that how to evaluate, how to apply the provisions that we discussed in the class. Okay. So I think now time is over. With this, 2 topics left. So basically the substantial portion we have covered, and the weightage of this topic 5th is 20 marks. So one full-fledged question will be asked in this particular chapter also. In next class, we will discuss chapter 6 and chapter 7. In the chapter 6, basically we will discuss because all those aspects of CCI. Because under the Competition Act 2002 established the Competition Commission of India. When it was established, it was an adjudicatory body, but now it is a regulatory body to regulate, to control the market, to control the behavior of enterprises, so there is a healthy competition in India. Okay, so with this, today class is over, and now you are welcome to ask anything as per your topic 120 marks, one
Thank you, sir.
question.
Thank you, sir.
Yes. And in that also, if it will it will OBE online exam, then practical question will be asked. So you can expect that this case of CCI versus SAIL, or this Brahmdutt versus Union of India. But if it is offline exam, then even the examiner can ask that what is the difference between MRTP and Competition Act, or the salient feature of the Competition Act, or how the competition law developed in India, or what is the development of the competition law after passing the Competition Act, because Brahmdutt case and then other development happened after 2002 also. So that type of the question, according to the ingenuity of examiner, can be asked in the exam. Any other thing?
So, since you've recorded the class, where would this recording be put up in case we want to rewatch it?
See, in the class, last class also I put that recording, and you can find, you will get the notification to, I think, your mail that the class has been put, that something has been uploaded by the teacher. So from there you can read, you can listen the lecture.
Sir, one more question, sir.
Yeah, yeah.
Sir, can we get last year paper, question paper, previous year question
Sure,
paper?
sure, sure. Why not? Why not?
सर ऑन गूगल
It's my
क्लासरूम
job.
आप प्लीज अपलोड कर दीजिएगा सो दैट सबको मिल जाएगा.
But this is very preliminary step, na? So first, during 3-4 classes, we have some idea कि ये competition है क्या. Basically, ये पेपर में हम पढ़ेंगे क्या, किस तरह से हम डिस्कस करेंगे, क्या अप्रोच होगी, and basically किस तरह मार्केट में, because नए स्टूडेंट के लिए it's very difficult, even for some teachers also who does not belong to this competition subject. They ask me that what type of the competition and how it is related. Because when we will discuss the market, like it is automobile market, it is aviation market, it is real estate market, and in that market also we demarcate through the geographical area, because the geographical condition of supplying the goods or services in one region may different from the another region. And so like आप देखो कि जो पैक्ड वाटर बोतल है 20 लीटर्स की, जो बिस्लरी या जो किनले वगैरह की 20 लीटर की जो पानी की बोतल है, that have the market in NCR, but rural area में उसका कोई मार्केट ही नहीं है, and that market may be different from Delhi to Bangalore. Okay, so particular interest, yes, and that's why first 3-4 lectures we will discuss all about these things, even the laws that are prevalent in US, UK, and European Union. And some, with every chapter we will discuss how the position of competition in India is different from there, whether they are have the good law or more effective provision, or we have less effective provision. All these things we will discuss, and definitely I will put question paper also. We will discuss questions also, because this time last year it happened that classes started from 1st of I think September, and then with the I even didn't have any notice, and then I was of the opinion that classes will be extended, because generally we started classes from August, but in that last time we have to conclude all the syllabus, so teachers did not find much time. But this time our classes started with the regular schedule, and so we have enough time to discuss even the question paper, to discuss the cases, to discuss the provisions and all these things. So don't worry, I will upload the question paper and other stuff, other material, study material, even the books if that is available online, even some other things if I find that it is helpful for the student. All these things will be uploaded in this class. Okay. Yes, any other question if any of you want to ask? No? Okay.
No, sir, I don't
Okay.
think so.
Okay, then class is over. Bye.
Okay, thank you so much, sir. Thank you so
Thank
much.
you. Thank you.